talk lifetime gifting strategies to your children. Hi, I'm Claire at the Yanowitz Law Firm, where we've been helping families with tax-wise gifting now for over 30 years. So there is a potential sunset in the federal estate tax exemption in 2026, so it may be chopped roughly in half. So with that, people are considering making gifts right now to take advantage of the higher exemption. So sometimes people feel like they have adequate assets and now is a good time to make some of those larger gifts to children. And so there's a couple of considerations that you should think about if you're thinking about making a big gift to your kids. So first, should it be outright or in trust? So a lot of times when people are making these larger 6 or 7 figure gifts to kids, they want it to be in a trust because it can provide asset protection in the event the child is sued, goes bankrupt, even gets divorced. It can act as protection. So that's one reason. Another reason that people might choose to give it to their children in trust is if the child is oh so wealthy, we can make it so that these assets are not subject to estate tax at the child's death. So that can be another benefit of putting it in trust. A third benefit is the parent can dictate how this asset will pass when the children pass away. So if they want to ensure that this asset descends down the bloodlines to the children of that child, so the grandchildren, as opposed to maybe a son or daughter-in-law, we can kind of indicate how this property is going to pass throughout time. So if you are interested in making a large gift to your children this year, and specifically to an irrevocable trust, then we have to look at, okay, what assets are you going to give? And the perfect asset to give is one that kind of has a high basis now, but is set to explode in value in the future. Why is that? Because gifted assets do not get what's called a step up in basis at the time of your death. You've given them away, and so your kid gets what's called a transferred basis. They get a basis equal to what your basis was in the property. And so as a result, you miss out on this income tax benefit of getting this basis readjustment at death. So you want to give high basis assets. Now you want to give assets that are going to explode in value in future. Why is that? Because whenever you set up these trusts, you file a gift tax return. You say, okay, I'm giving the farm is worth $500,000 today. So what that does on the federal side is it reduces your federal estate tax exemption by $500,000. The value of the date of the gift, that's how much it dings your federal estate tax exemption. So if it's worth $500,000 in 2024, but you die 20 years from now when the asset is worth $20 million, for example, you essentially have shifted $19.5 million of wealth to your children without paying estate tax on that. Whereas if you died with that $20 million asset, you'd be paying estate tax on the full $20 million. But in this scenario where you're gifting the asset when it's worth $500,000, you're only getting dinged for $500,000. The other thing to account for is Minnesota estate tax. So Minnesota has what I like to call kind of like the forgiveness rule. The federal government never forgives. You make a big gift when you're 21, it's gonna ding you at the time of your death. They don't care when you die decades later. You could die a century later. They don't care. They're gonna never forgive you and ding it into your exemption at death. Whereas Minnesota, we're nice here. We forgive. So we forgive these big gifts, and as long as you don't make them too close to the time of your death. We don't like deathbed giving here. So as long as you make this gift more than 3 years of your death, then it's totally out of your estate for Minnesota estate tax purposes. So if you gift in 2024 and you die a decade from now, Minnesota says, you know what? Let bygones be bygones. We're going to ignore that you made this gift a decade ago, and we're not going to subject to Minnesota estate tax. So that's how that works. Now, when we look at making these gifts for children, it can be in like a combined trust where you kind of like have a pot trust where all your children are beneficiaries of it while you're alive, and then at the time of your death it probably splits into equal shares for your each individual children. I like doing that type of trust if we're putting marketable securities, easily dividable assets, or something that we want the children to co-own for the long run, like the family cabin, maybe something like that. Now, I do not like creating this pot trust idea for assets that really shouldn't be shared with children. Like, let's say we have one child that's on the farm, they're farming, the other children are not involved. Maybe we put that into a separate trust trust for that child. And then maybe this other kid uses the cabin and you want to give them the cabin and you don't want to co-own with the siblings. You put that in a second trust for that child. So this can work well if there are certain assets that create an individual trust for each child if the children shouldn't be co-owning these assets long term and they aren't like marketable securities. Thank you so much for your attention. If you have any questions about gifting to your children, big and small, we're here to help. This kind of touched on bigger concepts, but we're also equipped to answer all sorts of smaller size gifts to descendants. Give us a call. We're here to help. Our number is 507-252-8997. Again, that number is 507-252-8997. Thank you.